Hi, this is Quintella Griffin with Realty, and today I will be doing a presentation on why the preliminary report is so important, and this applies to sellers and buyers. Hi, this is Quintella Griffin with Realty, and before I begin my presentation, I'd like to do a disclaimer. The information you obtain in this presentation is not, nor is it intended to be legal advice. You should consult with an attorney for individual advice regarding your preliminary report. If you feel it is required, the information in this presentation is not a substitute for personal legal advice. Thank you. Hi. A preliminary report is a report made before a title insurance policy is issued. It shows the ownership of a specific parcel of land together with the liens and encumbrances thereon, which will not be covered. So liens and encumbrances is not covered um, under the title insurance. And we'll go into this further on into the presentation. But for right now, I just wanted you to understand what a preliminary report was. Okay, I'm going to go over with you now on how to read a title report. So I'm just going to break the title report up into 3 sections and go over that with you and explain it. Okay, so section 1 in the preliminary report is the section that contains the who, the what, the whom, the details of the transaction. It sets the effective date of the report, the names of the current property owner, which is the seller, buyer, escrow officer, and the order/escrow number. So it contains the escrow number. So if you don't know your escrow number, you can find it in this section of the report. Section number 2. This section contains the requirements. It lists the terms that must be cleared up or satisfied in order to issue a policy covering the new owner and or lender. For example, you might need to get approval from a bankruptcy trustee. There could be signatures that are required. A former spouse may be required to sign, an heir, or documents or release of various types of liens, etc. may need to be met before you can obtain the title insurance. And then we have section 3 of the report. This section notifies the buyer and or lender of the exceptions from the coverage. For example, it might not include the restrictive covenants or mineral rights or water rights or utility easements. Like that could be like a um, something from PG&E that's on the property that they have to access to get onto your property. So these exceptions from coverage will not be insured on your title policy. The exceptions vary from title and escrow companies. So all policies are not the same. Each title company has their own criteria. And then in the preliminary report, you'll also see Exhibit A, which will have the legal description of the property. So your real estate agent should always go over the preliminary report because this document is one of the most overlooked documents, I believe, in the real estate transaction. The realtor just forwards it over to the buyer and says, look at it, or the seller, they don't go over it with the seller. They just assume that you understand it and what the purpose of it is. So it's really important that you go over this document because it could actually have some relevant information in there that could be detrimental to your transaction. Okay, thank you. Okay, I'm going to briefly cover liens appearing on the title report. This is really important. Um, So you might see on a preliminary report judgments and liens after BK, and not necessarily after a BK, but they could just be judgments and liens. But there might also be judgments and liens after a BK. So you really need to do a very in-depth analysis of the preliminary report. Again, this is one of the most overlooked documents I personally feel in the transaction. So if there is liens on the property after a BK, you may need to hire an attorney to remove the liens or do what they call a motion to avoid the liens. And I can tell you right now that's a 45-day process. So if you're in the middle of escrow and you realize you have this situation, it's going to postpone the close of escrow at least by a minimum of 45 days. so you can do the motion to avoid a lien. So you really should try to analyze this before you go into escrow so you don't have this situation. Then we have utility liens. There could be liens from the PG&E, there could be liens from water, liens from garbage. It's not uncommon to see a ton of garbage liens on the property, which will be paid by the seller at the close of escrow. It'll just come out of the sales proceeds. And then mechanic liens. Mechanic liens are liens that are made against the property for work performed, like if it was construction or new bathroom remodeled and the seller didn't pay for it. Anything dealing with remodeling or some work or labor done on the property and there's a lien placed on it, that will have to be cleared before you close escrow. There's so many types of elements in this area that I could go on and talk about this in a whole separate video, but you get the point, that on the preliminary report, these liens need to be cleared up, judgments need to be cleared up. So make sure that you are aware that there are liens or judgments or issues with the property that is not going to delay your closing. Your realtor should be able to look at this and do a thorough analysis and get over this hump in escrow if you have this problem. Okay? Thank you. In a real estate transaction, you're going to hear this word more than once. CC&Rs. So what does CC&Rs stand for, and what is CC&Rs? CC&Rs on the property dictate what you can and can't do on your property. Yes. They're rules, always rules. So it stands for covenants, conditions, and restrictions. And these are usually placed on the property either by a builder, a developer, HOA, homeowners association. And you can find the CC&Rs actually in the preliminary report. Most of the time they're embedded and linked in the preliminary report. So I will go over the CC&Rs with my clients. And so some of the things that you might see in a CC&Rs are like restrictions on what kind of dogs are allowed in the neighborhood. Things like you can't paint your house a certain color without permission, or remove a tree. It could be anything, or add trees or landscaping. So these are things that you need to be aware of before you purchase the house, because you might not like the restrictions. So your real estate agent should always go over the CC&Rs before you get to the closing table to sign your documents. Okay? All right, thanks. Title insurance. So we know that in a transaction, the buyer is usually gonna purchase title insurance, and that's open to negotiation. The seller could be the purchaser of the title insurance also. So I'm just gonna talk a little bit about the different types of policies that they have, so you can get a better understanding. And so a lot of people always ask me, so why do I really just need title insurance? It's just an added expense. No, it's not an added expense. It is an added expense, but you want to have title insurance so if there's an issue with the chain of title down the road, the title company will pay a claim or represent you, get you representation if someone came back and said, oh, there was a forgery and the property is really mine. So you definitely want to have title insurance. And so the basic owner title policy coverages, here's some of the things that it covers: clear title to the property, incorrect signatures on the documents, forgery or fraud, restrictive covenants, encumbrances, and judgments. So you see there, this is a basic owner's title policy coverage. And then next we're going to go to basic lender's title policy. So this is a lender's mechanic liens and unrecorded liens, because people do forget to record liens, but they still have them. Unrecorded easements and access rights, defects, and other unrecorded documents. So you want to be, the lender might want to be insured against this type of issues that may be going on behind the scenes that you don't know about. Extended owners coverages. These are other things that you can have added to the policy. Building permit violations from the previous owner, subdivision maps, covenant violations from the previous owner, living trust, structured damage from mineral extractions, and variety of encroachments and forgeries after the policy has been issued. So I have with me here, which you can't see that I'm reading, but I have a preliminary report in my hand on a transaction I'm in right now in Vallejo, California. And the title company is Old Republic Title Company. And so when you get the preliminary report is going to contain the information in here. I'm just going to read to you what it says. So with respect to the title insurance, it says the form of policy the insurance contemplated by the report is homeowners policy of title insurance. AT, and then it says and ALT loan policy. And then it says a specific request should be made if another form or additional coverage is desired. So in this transaction that I'm in, it's telling me in the buyer in this report what type of coverage is being issued in this transaction. All right. Okay. If you have any questions, after this presentation, you can email me or you can call me if you want more information on a title insurance, or if you're in the middle of a transaction, you can always talk to your escrow officer about the type of title insurance that you are purchasing. And there's all types of videos on YouTube about what title insurance is. Okay, thank you. Your realtor in escrow. Now this is extremely important. I have to stress this, because escrow is easy to get into. Escrow is you can do all the negotiation if you're representing the buyer to get into escrow, or you can take a listing and get into escrow when you get a buyer on the property. But to get through escrow is another thing. You have to have a very set of skills, special skills, to make sure you can always get through the escrow. So here are what I find to be the most important skill set when you are looking for a realtor and representing you as a seller or a buyer. They need to be able to have great communication skills, because you're going to be communicating with the escrow officer. You have to have excellent problem solving skills. It is mandatory, because you're going to run into a lot of problems in escrow. I've never seen a perfect close. Understand escrow process. You have to understand the way escrow flows, the process, what is expected of you. Oftentimes the escrow officer is going to be calling you and asking you either for documents or asking you for information about the buyer or the seller. And one of the things I find from some of the escrow officers that I work with, their biggest complaint is that the real estate agents are very delayed in responding back to them, or will tell them, oh, we're going to close on this day, and expect that, they're going to close 2 or 3 days from now, when in fact there's a whole bunch of conditions that haven't been met that need to be cleared up. So it's really important that when the escrow officer contacts your realtor and asks for certain documents or certain things that they need, that the real estate agent gets it to them right away, because the the escrow officer is not just sitting there waiting for your realtor to respond to them. So in some transactions, I call this what they call special niches, and I have a lot of special niches. But so, for example, bankruptcy is a special niche. Probate is a special niche. Selling properties in foreclosures is a special niche. You need to make sure that the escrow and title company that you work with, and especially the escrow officer, really understands the flow and the process, because it's not just involving, um, we'll say for example in probate, it's just not a regular transaction. So there's things that you're going to need from the attorney, or things, documents, court orders, a probate court order, a notice of proposed action. There's going to be additional things outside of the regular transaction that you will need. If you're in a bankruptcy sale, there's going to be, the trustee is going to regulate the whole transaction. And so you need to know what the expectations are, how to get a demand over to the bankruptcy trustee. And this is not coming from the realtor. This is going to be from the title company. So you have to work with the escrow officer or a title company that specializes in closing transactions, like in a bankruptcy sale, in the probate sale, in the foreclosure sale, with divorcing homeowners, because those are special niches, and the escrow officer has to be skilled and experienced in handling escrows, those types of escrows. And then you need to work with a realtor that knows how to close the deal and overcome hurdles in escrow, because there's going to be a lot of escrow issues that come up. So I'm going to give you an example of a hurdle that I had to overcome about 4 months ago. So I had a probate transaction that I was working on, and the attorney did a motion to have the judge pretty much make one personal representative in charge of the whole transaction, and then take the monies from the sale and put it in a blocked account, and let them finish arguing over it or debating who was going to receive what. So what the judge did was he converted the order to a sale by partition, which is not inside of the probate. So he did a sale by partition, splitting up the property, saying, hey, the first personal representative has authority to sell on behalf of the whole entire probate case, which there was multiple probates open. And so that kind of threw off everything. So I opened up with one title company. They was like, no, we can't close it because there's too many factors going on. Okay, so then I had to move escrow to another title company, and they took a look at it and they said, oh yeah, we can do it. As we got into the process, they're like, no, we need this from the court, we need that from the court. And I was like, well, it's not a probate sale, it's a sale by partition within a probate sale. And it wasn't something that was common, so it kind of got thrown off. Everyone was kind of thrown off about, like, how do we handle this? So then I took it to another, I transferred it to a third title company. And I have to tell you this, most real estate agents would have said, okay, we can't close escrow, the attorney needs to do more work. Or they would have just said, you know what, this is a deal crasher. And it literally is a deal crasher, because if you went through 2 title companies already and they tell you that they can't close it because they need XYZ as a criteria in order to close it, then that's it. That's a wrap. But I didn't give up. I went to a third title company and I explained everything that was going on. I got all the documents before we opened up title this time, before we opened up escrow. And then I also requested a meeting with the senior title advisory, and I explained all the process to her, what was going on. And based on the information that I provided them, they said, yes, we can close escrow, no problem. So I was able, I had to explain it probably about 10 times to everybody, but we were able to close with that title company without my client having to go back to court and get additional orders and documents filed with the court, thus saving her money from attorney's fees and times and costs, because she was ready to close, because she had been in probate for like 3 years. So, you know, you have to be able to think quickly how to figure out and how to resolve problems, because if you don't, that can crash a deal in escrow. So I pride myself in being able to resolve problems in escrow and resolve them and move on to the next transaction. I call myself the closer. Okay, thanks. I'd like to introduce you to my team. Of course, you already know me, Quintella Griffin. I'm a realtor. And then my broker is Anthony Ward with Ward's Realty and Loans, Inc. And then I have Trey that works with me. She's a transaction coordinator and my executor, and she is excellent at the management of my business. I don't know what I would do without her. And I also have a marketing team and other people that I work with, but there's no space for them. But I thank everybody that is on my team for working with me and helping me with my transactions. This is really important, and Trey is usually the person that will be sending over to you the preliminary report, because she gets it from the title company at the same time that I do, and she sends it over to the client to review. Okay, thanks. Why the preliminary report is important. This is the very most important aspect of this presentation. So I'm going to share with you some of my experiences and why I believe the preliminary report is very important. So the title could be clouded and need to be cleared prior to going into escrow. So this is something that you should be looking at. Look at the title report, analyze it, see if it's clouded. You will know if it's clouded. If you don't know if it's clouded, then you should probably be looking at little things that pop up with the escrow officer. They'll tell you if it's clouded. The seller does not have the ability to sell the property. For example, no authority to sign the listing agreement, need to go through probate or a contested trust. So I had this situation before. I had a little old man that was married that lied to me, that did not tell me that he was not the owner. I didn't ask to see the title. I hadn't did my background research, and I just believed him, and he told me, he was the husband and the wife had died, and he was like, it's my property. But come to find out, he wasn't even on the title. It was her sole and separate property. And so that was a mess. So make sure that when you take a listing, that the person that is signing the listing agreement actually has authority to sign it, and that is the owner of the house. Sometimes you will get listings and the person will say, I need you to sell my house, I'm the owner of it, blah, 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 blah. When in fact they are an heir and the person has died and they need to go through probate. Sometimes it might be one person on the title that died and the other person that didn't die. And the title wasn't held as joint tenants, so they need to go through probate. You might have a living trust and the person says, oh, I want to sell the property, I have authority to sell, and you sign a living trust, and then the heirs are like, no, we don't like this, we don't like that. So they end up filing probate, and they contest the trust. So you have to be aware of these types of things when you're going into escrow. Heirs are disputing the sale in a contested probate case. You should always ascertain the position of the heirs if you can, especially if you're the listing agent. That's going to let you know that when you get ready to go into escrow, what's going to happen. So if the heirs are all in agreement, yes, we want to sell, you pretty much know that you can do the transaction. If you have some heirs here and there that's saying, well, I don't want to sell it, or I feel that this should be done, and there's kind of some disputing going on between the heirs or the beneficiaries, you can most likely believe that maybe someone is going to be filing and contesting in probate, which is going to delay the sale. There's also a notice of proposed action that has to be filed. If that's not filed, that will delay the sale by like 15 to 20 days. So you really should, if you do probate sales, you should really be in tune with what documents are required to close escrow, because it could crash your deal or delay your deal, or the buyer could just walk away. um, from that for various reasons. It could be because they're not going to get the same interest rates, or they're tired of waiting, or you go to court for one thing and then there's something else that you need in order to close escrow in a probate sale. So you should make sure that you look at the title report, do some analysis, talk to the attorney, check the docket, look at the flow of the docket so you can kind of know what's going on. Liens on the property that need to be resolved. Sometimes there are liens on the property, for example, after a bankruptcy that attach to the property. A lot of times people think, oh, I filed bankruptcy, I discharged my debt, I no longer have liens, and then they get ready to sell it only to find out, oh, they got a ton of liens. How do I get rid of these liens before I sell my property? I don't want to pay these liens because I filed bankruptcy. Well, there's a process called motion to avoid a lien, and that process I can tell you, because I was a paralegal and I've done these types of documents. It's 45 days bare minimum, and if the attorney makes a mistake or has to amend something, it could be another 45 days. So you really want to be clear about that before you go into escrow. It could be a problem. Um, why is the prelim so important? Because it helps you negotiate. I mean, you might not be paying attention. You might open up escrow, and when I'm representing the seller, I always open up the escrow and I ask for the escrow officer to give me a copy of the prelim. I look at the prelim and I ascertain, you know, has there been bankruptcy? If there was a bankruptcy filed, are we going to need to do any types of motions to avoid? I don't want to put it on the market. I don't want to go into escrow if we have that situation. If there are mechanic liens that need to be cleared up. Um, if there's a lis pendens on the property, a lis pendens is like a notification that there is litigation going on. You can't even close escrow when there's a lis pendens on the property, so you can forget it. Unless the only way you can close if the lis pendens is withdrawn, the case is dismissed, or there's some type of agreement between the parties that they're going to remove the lis pendens so you can close escrow. You can't close escrow. So you need to be checking to see if there's any lawsuits, if there's a lis pendens, if there's a mechanics lien, if there's liens attached to the property. Um, there's all kinds of things. So say, for example, you're in you get a listing, you're in foreclosure, and you haven't gotten the escrow yet. The auction date is coming, and the trustee will not give you an extension. You got to know how to resolve these issues. These are all issues that can come up. I have a list of them here. This is not inclusive list. There's so many more things that can happen than these small little things, but these are just little things that you need to be paying attention to. Even sometimes what happens is that you will go into escrow. You might order, say you open up escrow in January, uh, and you get the preliminary report, but you don't put it on the market for, say, like another 2 or 3 months or so, and you get ready to go into escrow, and then you find out that there's another judgment that's been recorded against the property. That might cause a problem um, in your negotiations, or it might cause a problem in the sale, in the transaction. So many things come up. So you need to be paying attention as the real estate agent. Since you're representing the seller or the buyer, you need to be looking at these types of things, like when escrow was open, was there already a prelim order? You need an updated prelim. It should be showing. Sometimes if you are representing the buyer, you look at the prelim, oh, they're in bankruptcy, oh, we can negotiate on the price. Or you're in foreclosure, you can negotiate on the price. These are things that a lot of times real estate agents don't look at because it's insignificant to them, or they just wait until they get into escrow to look at these types of things, and then they find out, oh, the deal is going to crash because they didn't look at the prelim, or there's issues, and they just, you know, you got to pay attention to this document. It's extremely important. I can't stress that enough. Take a look at the prelim, review the prelim, look at the hyperlinks, download the documents, look at the deeds, look at everything that is attached to that prelim. Go over it with the escrow officer, and figure out what you need to do to close escrow. That's part of your job as a real estate agent. All right? Okay, thank you very much. Again, I'm Quintella Griffin with Ward's Realty. Thank you so much for watching my presentation. If you have any questions about why the preliminary report is so important, feel free to give me a call at 925-237-1310, or you can email me at agentqrealtor@gmail.com. If you are interested in listing your house for sale or you're thinking about buying, please feel free to give me a call. I have referrals for buyers. And when I say referrals, lender referrals, I have lenders that have excellent programs, first-time home buyers, down payment assistance, assistance with closing costs. I have excellent lenders that I work with. If you are thinking about selling your house, now is a good time. You can go on Facebook if you like and book an appointment with me, or you can give me a call. I can help you with so many things. Again, I'm Quintella Griffin with Ward's Realty. Thank you so much for watching my presentation and have a great day. Bye-bye.